explaining how a cease and desist letter works for trademark infringement in Oklahoma. Protecting your brand from trademark infringement is central to your company's identity. The world of commercial branding moves fast. In Oklahoma's competitive market, a distinct business name, logo, or slogan is one of your most valuable assets. It's your identity. But what happens when another business starts using a name or logo that is confusingly similar to yours? Or, conversely, what if your business suddenly receives a formal letter accusing you of stealing someone else's brand identity? This is where trademark infringement claims and cease and desist letters come into play. Understanding how these two legal concepts interact is vital for protecting your business and avoiding catastrophic rebranding costs. 1. What is trademark infringement? At its core, a trademark is any word, phrase, symbol, or design that identifies the source of your goods or services and distinguishes them from competitors. Trademark infringement occurs when a competitor uses a trademark that is identical or highly similar to a registered or established trademark, creating a likelihood of confusion among consumers. The key test: the legal standard isn't whether the two marks are 100% identical. The question is, would an average consumer be confused about whether the two businesses are connected, affiliated, or sponsoring one another? When determining if infringement has occurred, courts look at several factors, including the strength of the original trademark, the similarity of the two marks in sight, sound, and meaning, the proximity of the goods or services, e.g., two distinct restaurants versus a restaurant and a tech company, evidence of actual consumer confusion. 2. Enter the cease and desist letter, the first line of defense. If you discover that someone is infringing on your trademark, or if someone believes you are infringing on theirs, the legal process rarely jumps straight to a courtroom. Instead, it almost always begins with a cease and desist letter. A cease and desist letter is a formal document sent to an individual or business demanding that they immediately stop an allegedly illegal activity, the infringement, and refrain from doing it in the future. While it is not a court order, it carries massive legal weight. It serves three primary functions. A. It establishes notice, eliminating the innocent infringer defense. To recover significant monetary damages in a trademark lawsuit, we often need to prove the other party knew they were doing something wrong. Sending a cease and desist letter puts the infringer on formal notice. If they continue using your mark after receiving the letter, their infringement becomes willful, which can triple the damages a court awards you later. B. It minimizes legal expenses. Litigation is expensive, time-consuming, and stressful. A well-crafted cease and desist letter opens the door to negotiation. Often, a competitor simply didn't realize the conflict existed and will agree to phase out the confusing mark, saving both parties tens of thousands of dollars in court fees. C. It preserves your trademark rights. If you own a trademark, you have a legal duty to police it. If you knowingly allow competitors to infringe on your mark without objecting, the mark can undergo genericide or loss of distinctiveness, meaning you could lose your exclusive rights to it entirely. Sending these letters proves you are actively defending your brand. 3. What should a cease and desist letter include? A professional trademark cease and desist letter should never sound like an angry rant. It needs to be a precise, clinical statement of legal fact. It typically includes proof of ownership, details of your trademark registration, USPTO numbers, dates, or evidence of long-term local use if relying on common law rights. The infringing conduct. Specific examples of how, where, and when the recipient is using the confusingly similar mark. The legal demand. A clear directive to stop using the mark, remove it from websites/marketing materials, and destroy infringing inventory. A hard deadline, a reasonable time frame, usually 10 to 14 business days, for the recipient to comply or respond in writing before further legal action is taken. 4. What if you receive a cease and desist letter? If an envelope arrives at your office accusing you of trademark infringement, do not panic and do not ignore it. Ignoring a legitimate letter can turn a manageable dispute into a federal lawsuit. Take the following steps immediately. Do not respond right away. Avoid calling or emailing the sender in a defensive panic. Anything you say can be used against you if the matter goes to court. Preserve evidence. Do not immediately delete your website or alter your branding until you have legal counsel, but do look into when you first started using the mark. Consult a business attorney. Our business law attorneys will evaluate whether the sender actually has a valid claim. Sometimes these letters are trademark bullying tactics sent by larger companies with weak legal standing. Other times they are valid, and your attorney can help negotiate a safe phase-out period so you don't ruin your business operations while transitioning to a new name. 5. Business lawyers protecting your brand strategy. Whether you need to enforce your trademark rights against a competitor encroaching on your market, or you need to defend your business against an aggressive infringement claim, handling the situation correctly from day one is critical. For a free consultation with one of the Oklahoma business law attorneys at Kania Law Office, call 918-743-2233.